Hello friends, in the series on the income tax cases, we will discuss a very important case of Bombay SAMACHAR Private Limited versus Assistant Commissioner of Income Tax. This case is reported in 107 ITAT Tribunal, short notes 57. The matter has been decided by Honorable ITAT Mumbai B bench and the date of the judgment is 3rd October 2023. This case is on section 50C, which talks about special provision for full value of consideration in certain cases. That means that if the assessee sells any land or building or both land and building, and if the sale consideration is less than the stamp duty valuation, then the assessing officer shall adopt the stamp duty valuation as the sale consideration. This provision is very harsh because it suggests that it is a straitjacket formula. Now, in the days of recession, when the properties are not selling at the value which is there in the stamp duty valuation, and in a number of the cases it is the position that the market price is less than the stamp duty valuation, then there is a genuine problem for the assessee, that assessee goes into the litigation because the assessing officer tries to adopt the stamp duty valuation. But there is a safeguard in section 50C, that is section 50C subsection 2, that if the stamp duty valuation so adopted is not in dispute in any appeal, revision or reference before any authority or court or high court, then in that case, before adopting the stamp duty valuation, the assessing officer has to refer the valuation to the department valuation officer. Without referring the matter to the department valuation officer, the assessing officer does not have the power to replace the sale consideration by the stamp duty valuation. In the present case, the assessee sold a piece of land in 2.75 crore. The stamp duty valuation was 4.99 crore. During the assessment proceedings, the assessee was show caused that why the sale consideration should not be replaced by stamp duty valuation of 4.99 crore. The assessee gave the reply that since the ownership of the land is in dispute before the Honorable High Court, so the assessee is not able to fetch the exact price. So this was the reason which was given by the assessee for the lower sale consideration, but the learned assessing officer was not convinced with the assessee. So in that particular situation, the assessee moved to the CIT appeal. So CIT appeal also dismissed the appeal of the assessee. When the matter came before the ITAT said that in this case, both the conditions of section 50C subsection 2 are fulfilled, and in the present case, the viewpoint of the assessing officer that since the stamp duty valuation is in dispute in the High Court, for that the ITAT said that the stamp duty valuation is not in dispute in the High Court, but only the ownership of the property is in dispute. So the condition that stamp duty valuation so adopted was not in dispute in any appeal, revision or reference before any authority or court or high court applies, and it was the mandate of section 50C subsection 2 that the assessing officer has to adopt and go for the department valuation officer report before taking the stamp duty valuation as a gospel truth. So in the present case, if the assessing officer adopts the value of the stamp duty valuation as a straitjacket formula, that he is at error and he does not have the power to do so. So in the present case, the ITAT remanded the matter back to the assessing officer for doing de novo assessment. Friends, this case is very important because in section 50C, there is an inherent safeguard that the assessing officer cannot take the stamp duty valuation directly. He has to pass the hurdle of valuing the in referring the matter for the valuation to the department valuation officer. Only then, when the report comes, then again he has to give the assessee an opportunity to counter the department valuation report, and then he can adopt the stamp duty valuation. So friends, this case is very important as far as section 50C is concerned. At the end of this video, once again I am repeating the name of the case. The name of the case is Bombay SAMACHAR Private Limited versus Assistant Commissioner of Income Tax, and this case has been reported in 107 ITR Tribunal, short notes 57, and the matter has been decided by Mumbai ITAT B bench, and the date of the judgment is 3rd October 2023. Thank you, friends.